Good morning, everyone, and welcome to our employment law update for higher education institutions. There's still some people joining us, but I think we'll make a start. So we've got a lot to get through today. Just a reminder that this session is being recorded, and we hope to get the recording out to you in the next few days. So welcome to the session. I'm Jane Byford. I'm a partner and I head up the higher education practice at VWV. And my co-speaker today is Katie Hurst, who's a senior associate in the employment team, and she specialises in advising higher education institutions on employment law issues. In the background, we've got Natalie, who's operating the slides, and Tamar, who can deal with any queries you may have. So if you've got any queries, please do pop those in the chat. And if you've got any questions, please do put those in the question and answer box, and we'll try to deal with those later. So we can move on to the next slide, please, Natalie. So there's two main things that we're going to cover today. The first is the Employment Rights Bill, which there's been a lot in the press about. So we'll try and summarise what's there and what isn't there at the moment. And then we're going to give you a case law update, focusing on cases that we think are particularly relevant to higher education institutions. And hopefully then there'll be plenty of time for questions. So as I say, please put those in the Q&A box. So moving on to the next slide and the Employment Rights Bill. And this was introduced on the 10th of October. It basically builds on what was in the Labour Party's election manifesto commitments. There was a lot in there on the changes they were going to make to the employment laws in this country. And those proposals are set out in the Employment Rights Bill. And it was introduced just about on the 100-day deadline that the commitment from the Labour Party was. And it basically, as I say, builds on those commitments set out in the manifesto. It's a huge piece of legislation. It covers a lot of different issues, and we'll summarise the main ones we think are relevant to higher education today, but there's a lot more in there. Last week, there was an amendment paper published, 27th of November, which basically was 53 pages of amendments, some of which the government is proposing already, and some of which other politicians are proposing as it's going through the House of Commons. The key amendment is that the time limit for all employment tribunal claims will be extended from 3 months to 6 months. That was something that was in the Labour Party's manifesto, so it was a bit strange that it wasn't included in the bill, but that's the proposal now is to rectify that. So all tribunal claims would be extended to 6 months, which I think could be problematic for universities. It means there's a much longer period in which people can bring claims. It means you're going to have to retain your records for a longer period and so on. A lot of the proposals are subject to consultation. The consultations are still ongoing, so that will allow for refinement. It allows for people like universities to the public to give feedback and on what the impact of the bill will be and how to address practical issues. So it's your opportunity to feedback into that. A lot of the detail is going to be in secondary legislation, in regulations. So when we say that we don't know the detail today, it is the case that it is going to be in secondary legislation. The government has also published its paper, Next Steps to Make Work Pay. That summarises how they're going to implement the Employment Rights Bill, but it also sets out a commitment to review various other parts of employment law. So that includes a review of parental leave, consulting on a single worker status, so perhaps merging worker and employee status, and also a review of TUPE. So there's a lot more potentially that is going to come. Katie, over to you.
Thanks, Jane. So starting with the topic of unfair dismissal, so as you may know, there is a plan to remove the 2-year qualifying period for employees to bring claims of unfair dismissal. So it will be a day one right. Jane has mentioned the amendment paper, and we understand from that there is a proposed, what some people are calling a statutory probation period, but a proposed probation period of between 3 and 9 months. Again, the detail of that will be set out in later regulations, but we understand that that 3 to 9 month period is what's being considered. And during that period, what we expect is that there will be a sort of lighter touch procedure that employers can follow in order to dismiss. But nevertheless, it seems that day one right is going to come in. So the employer will have to show that the reason for dismissal is related to conduct, capability, statutory restriction, or the catch-all provision of some other substantial reason, or SOSR. So even if the dismissal takes place during whatever that statutory probation period might be, there still needs to be a fair reason, although the procedure is expected to be slightly simplified. Importantly, dismissal for redundancy is not included on that list. And what that means in practice is that from day one, an employee would be able to bring a claim for unfair dismissal if they were to be made redundant. The other thing to say in relation to unfair dismissal rights is that dismissals on the grounds of SOSR, so some other substantial reason, talks about that reason being related to the employee, which is a slight change to the current position. So it suggests that something like a dismissal connected with a business reorganisation would not be covered, and so employees could bring a claim for unfair dismissal, and the reason itself would have to relate to the employee. So it could include, for example, a breakdown in working relationships. So moving on to the next slide, please, Natalie, and I'll hand back to Jane.
Okay, so the bill also introduces new protection for maternity returners. So as you're aware, the current position is people who have informed their employer of their pregnancy, are on maternity leave, or for 18 months after childbirth, have a priority right to be offered suitable alternative vacancies if there's one available in a redundancy situation. So it's a priority right above other employees to be offered any suitable alternative vacancy. The vacancy's got to be suitable, it's got to be appropriate, and it's got to be on terms and conditions that are not substantially less favourable than their current terms and conditions. And if they're not offered that suitable alternative employment and the suitable alternative employment available, that any dismissal for redundancy can be automatically unfair. There's also a right not to be discriminated against on the grounds of pregnancy or maternity. Now, what the bill does is gives the government power to introduce regulations to cover other types of dismissals that aren't redundancy, either during pregnancy, during maternity leave, or following a return to work. So that could provide further protection for employees who are pregnant, on maternity leave, or following return to work in all kinds of situations rather than just a redundancy situation. And it won't ban dismissals of women who are pregnant, but it seems to be that for at least 6 months after a return to work, that they will only be able to be dismissed in specific circumstances. The detail is very much left to regulations, so it's unclear how far the law will go, but it does seem to be a significant change that will affect for universities going forward. Also worth mentioning that the regulations are going to be clear that it applies to other forms of family leave, so adoption leave, shared parental leave, neonatal leave, and paternity leave as well. So a significant change, I think, and we'll wait further details in relation to that. We can move on to the next slide, please, Natalie. So there's been much talk and some changes as far as fire and rehire are concerned. It's been a hot topic. There have been some high-profile cases in the news. And from July 2024, July this year, a statutory code of practice on dismissal and re-engagement was introduced. And the government didn't at the time include a power to increase protective awards, but that is going to be introduced now from the 20th of January. So from the 20th of January, a tribunal will have the power to increase a protective award by up to 25% where an employer has failed to follow that statutory code of practice. So that's a new change from January next year. But the bill goes much further than that. It's not going to completely ban fire and rehire, but it is going to heavily restrict it. And it's no longer going to be a method by which you can dismiss employees and re-engage them on new terms and conditions, unless there's without the possibility of facing an unfair dismissal claim and a really strong possibility of facing such a claim. So dismissals will be unfair if the reason for it is either the employee hasn't agreed to an employer's attempts to vary their terms and conditions, or an employer intends to hire somebody else on different terms to perform the same role. It's a major shift from the current situation where you just have to have a sound business reason really to change terms and conditions to fire and then but give notice and then offer to re-employ on new terms and conditions with a sound business reason. So there will be very limited exceptions where an employer can fire and rehire. And that's where an employer can demonstrate that a dismissal is necessary due to financial difficulties that threaten the viability of the business. So really it has to show there are no alternatives available to avoid making changes to terms and conditions. And if those changes aren't made, then the business is no longer going to be financially viable. That's a much higher bar than we have at the moment. And I think there's going to need to be evidence of financial difficulties and why the change in terms and conditions will keep the business afloat. It means you're going to have to, if you're going to rely on this, you're going to have to provide detailed financial reports. There's going to have to be significant consultation with employees and their representatives. So it's going to be making it much more difficult to fire and rehire. There's also going to be consultation on lifting the cap on protective awards. At the moment, it's 90 days pay, and consultation is going to take place, and the government is considering whether that cap should be removed or it should be increased. It really shows that there's a shift towards protecting employees from being forced into accepting less favourable terms and conditions, and really is going to be in very limited circumstances where fire and rehire is going to be able to happen, and really as a last resort. Katie, over to you.
So I'm just going to cover the position on flexible working. So the changes will build on the existing rights to request flexible working. So the Employment Rights Bill suggests that employees will have a statutory right to flexible working, and employers must grant the request unless two conditions are met. So firstly, that one of the statutory grounds for refusal applies. So those are the business reasons that we already have in place. So those in themselves won't change, but an employer needs to have one of those grounds, and it has to show that any refusal of a flexible working request is reasonable. And it's that second part which is potentially a significant change for employers. So there will be a higher threshold for employers to show that any refusal of a flexible working request is reasonable. We expect that there will be a greater burden in respect of consulting with employees in relation to flexible working requests. And should it end up in a tribunal situation, we also anticipate that tribunals would apply a stricter test in terms of assessing whether a refusal is reasonable. So it won't be quite as simple as the current position, which is as long as you have a sound business case, you're generally okay when rejecting a request. This will go further than that. The bill also includes a power for future regulations to specify the steps employers must take. So that might be in relation to consultation, which will be a more rigorous process. And of course, employers will need to be much more cautious when dealing with these. We expect that whilst lots of universities are quite flexible with staff, that there are likely to be more challenges to any requests that are turned down. So again, the devil will be in the detail, but that's definitely one to keep an eye on. Moving on to the next slide, please, Natalie. Bereavement leave. So the Employment Rights Bill gives the government power to introduce a day one right to a period of bereavement leave. So that's expected to be 1 week of bereavement leave for employees. The position in respect of the death of a child will remain as it is now, which is a right to have 2 weeks bereavement leave. But this 1 week is sort of, in addition to that, it's a wider scope. So again, the regulations will specify the necessary relationship that the employee has to have with the deceased, but we expect that it could be a similar definition to that which is used for time off for dependents. So spouse or civil partner, child, parent, or anyone who lives in the same household. The implication is that this will be paid leave rather than unpaid leave, but that's to be confirmed. So moving on to SSP.
Thank you, Katie. So another area that the bill covers is entitlement to statutory sick pay, and it introduces some changes to that to improve accessibility and fairness. So the first thing is that at the moment, statutory sick pay isn't payable until after a 3-day waiting period. So for the first 3 days, it isn't payable and then it kicks in. The bill proposes that it's payable from the first day of sickness, that those 3 working days are not going to apply any longer, and that an employee will be entitled to immediate financial support. So removing those waiting days. It also makes it removes the lower earnings limit. So at the moment, the lower earnings limit is a flat rate of, and it's £116.75 per week. At the moment, employees who aren't at that lower earnings limit don't get any statutory sick pay. What the bill's proposing is statutory sick pay will be provided to those employees at a prescribed percentage of their normal weekly earnings, and consultations underway in relation to that, but the percentage that they're talking about is perhaps between 60 and 80% of that, the normal weekly earnings. So statutory sick pay will remain payable for 28 weeks of eligible absence, but that the fact that it's payable to everybody, and the fact that there's not those 3 day waiting days may mean that you need to consider amending your policies and procedures, particularly if you mirror the statutory sick pay regime, and there is you have 3 waiting days before anyone receives sick pay. We can move on to the next slide, please, Natalie. So as you can see so far, the bill covers a variety of different issues, and the next sort of set of issues is for other family-friendly rights. And some changes again to improve accessibility and flexibility for employees. So the first thing is removing the length of service requirement for parental leave. That's currently a year, but it will be a day one right. also removed the length of service requirement for paternity leave. So at the moment, an employee has to have 26 weeks service by 15 weeks before the expected birth. That will be removed so that it will be a day one right to have paternity leave. Also, employees will be able to take paternity leave after they've taken shared parental leave, which they can't do at the moment. So as well as those specific changes, not in the bill, but in the next steps to making work pay are some other proposed changes. The first is a review of paid carers leave, a review of that situation, and also a broader review of the parental leave system, so the whole parental leave system, looking at how the existing provisions can be improved, and it could potentially lead to reforms, perhaps giving increased paid leave, greater flexibility in taking leave, and so on. So those are things, there's first, the length of service requirements are proposed to be implemented when the bill is implemented. Most of that is in 2026. But those other things are going to be consulted on the review of the parental leave system. So I think it's watch this space, but we can expect some further changes down the line. So if we move on to 0 hours contracts, now there's an awful lot in the bill about 0 hours contracts. So we've tried to sort of pull out what we think are the most relevant things for universities. So the basic thing about 0 hours contracts is they're not going to be banned, but there are going to be significant reforms. And that is going to result in a loss of flexibility for employers and greater protection for employees to provide workers who are on 0 hours contracts with more security, and really shifting the balance towards employees away from limiting the ability of employers to use these contracts. So if an employer uses 0 hour contracts, then after a reference period that's not defined yet, employees will have the right to be offered a guaranteed hours contract. The length of the reference period, as I say, is subject to consultation, but after a certain period, employers will need to offer workers more stability in terms of their hours. So they need to be offered a guaranteed hours contract, and that will specify the days of the week they work, the hours they'll be offered, or a working pattern, and that must reflect what they've actually been doing in the reference period. So after that reference period, basically, employers will have to offer workers a similar contract based on what they've been doing during that reference period. It's a significant change, and one area I think that will be particularly affected as far as university is concerned is perhaps hourly paid lecturers and how you pay them and how their hours are calculated. The bill also introduces a mechanism for termination where work ceases and diminishes. So even though someone may have a guaranteed hours contract, there is going to be a mechanism for termination there. Again, a lot of the detail is going to be in further regulations, but it is something to be watching out for as the bill progresses. Katie, back over to you.
Thanks, Jane. So sexual harassment, there's obviously been a lot of commentary on this recently, and in just October of this year, there were changes as regards the law. Most universities will be well versed in this topic, particularly given the OFS requirements. But the employment bill presents some further potential significant changes to the law around sexual harassment. So as of 26th of October this year, there is a duty on employers to take reasonable steps to prevent sexual harassment of its employees. Under the Employment Rights Bill, that will change to a duty for employers to take all reasonable steps, which is a much higher bar. So employers will need to show that they have done everything reasonably possible to prevent sexual harassment from occurring in the workplace. And importantly, there will also be a reintroduction of third-party harassment. So employers will also have to show that they've taken all reasonable steps to prevent third-party harassment. It's third-party harassment generally, not just sexual harassment. So again, that's a much wider scope in itself. And that introduction of the protection against third-party harassment, we anticipate will be a standalone right that an employee could seek to enforce. So again, regulations will be introduced in the future to set out what all reasonable steps might be. But many universities will have already made a start on making changes to policies and procedures, but it will be important to see what those regulations say about what employees need to do to comply with the duty to take all reasonable steps. Another significant change is that disclosures about sexual harassment will automatically qualify as protected disclosures for the purposes of whistleblowing claims. And as a result of that, any disclosures related to sexual harassment will not be able to be silenced or hidden by use of what's commonly referred to as non-disclosure agreements. So the sexual harassment disclosures will be protected in the same way as other whistleblowing complaints are currently protected. So quite significant changes there in respect of all reasonable steps, the requirement to take all reasonable steps to prevent third-party harassment, and also the fact that sexual harassment disclosures will automatically be qualifying disclosures under the whistleblowing regime. Then moving on to the next slide, unions, trade unions and consultation. There's quite a lot, again, in the employment bill on these topics in themselves. We've tried to pick out some of the pertinent points. So the proposals will affect how employers engage with unions and manage collective consultation processes. So one of the key changes is the proposal to remove the single establishment rule. The single establishment rule basically says that where an employer is proposing to dismiss 20 or more employees within a 90-day period, the duty to collectively consult is triggered. With the removal of the single establishment rule, what it means is where there are 20 or more employees who are potentially at risk of dismissal within a 90-day period or less, the numbers will be aggregated across different sites. So it means that collective consultation may crop up more frequently as a result of that. The bill also proposes to make it easier for trade unions to access workplaces. So unions would have a right to request access for the purpose of meeting, representing, recruiting, organising or facilitating collective bargaining. And there are also proposals around streamlining the process for unions to become recognised as representatives of the workforce. There are some provisions around the right to request access and whether employers can choose to negotiate terms of a legally enforceable access agreement with the union directly, or giving the union the right to apply to the CAC for it to order access to premises, etc. So again, something which may impact on universities. Moving on to the next slide, please, Natalie. So what happens next? The bill is obviously making its way through a process of parliamentary scrutiny before being passed as law. But again, as Jane has mentioned, even after that has happened, lots of the detail about how this will work in practice, what employers are required to do, what the potential impact is, will be set out in the secondary legislation. We do know that the government has said there will be a number of consultations on various different topics during the course of next year. So the ones that we know of relate to 0 hours, fire and rehire, trade union reform, and changes to statutory sick pay. And it's expected that much of what we've talked about today and all of the other proposals in the bill are expected to become law during the course of 2026. So it is some way off, but there are obviously significant changes which require lots of thought and planning on behalf of employers. So we'll continue to monitor the situation and provide further updates as that information becomes available. So just to mention the draft Equality, Race and Disability Bill, which is a separate bill to the Employment Rights Bill, but nevertheless a potentially important piece of law. So the government says that this bill, which it's proposing, will extend the right to equal pay for ethnic minorities and disabled people. So in the same way that we have equal pay on the grounds of sex, it's expected that that will be extended. We also anticipate mandatory disability and ethnicity pay gap reporting for larger employers who have 250 or more employees, which will be the majority of universities. So in addition to the gender pay gap reporting, there may well be mandatory disability and ethnicity pay gap reporting. Again, we don't know much of the detail about how this right will work in practice. There have been reservations expressed by lots of commentators on this, particularly around the difficulty and the complexity of pursuing claims for equal pay. They are very difficult things to do already. Whether claimants might find it difficult to point to an actual comparator, which is a requirement of the equal pay law at present, and also the limitations of these types of claims being in relation to pay only without there being any element of compensation for injury to feelings. So there are some reservations around this, but again, we will have to wait and see how that plays out in practice. So moving on to some case law.
Yes, thank you, Katie. So so that summarises what's going to happen in due course and the new rights that employees are going to have. But I want to do a bit of looking backwards and some of the recent cases that have been reported, particularly those that are relevant, we think, to the HE sector. So I'm going to cover the first three and then hand over to Katie. So the first case I want to cover is First Greater Western and Musa, I think is how you would say it. And this is a recent decision that basically says that employers can be liable for victimising employees who've previously made protective disclosures or done a protected act, even though the decision makers in the particular case weren't personally aware of the history. So here the claimant was a gate line operator at Ealing Broadway station. In 2012, he raised a written complaint and a grievance to the station manager. Following that, he was dismissed, and in 2013, he brought an employment tribunal claim for unfair dismissal and discrimination. The parties reached a settlement, and as part of that, he was reinstated in 2014 and transferred to Paddington Station. So some years later, 2018, whilst he was on duty with a colleague, the claimant called the police to deal with an alleged assault on his colleague by a passenger. So the station police commander advised that CCTV suggested that no such assault had actually taken place. On the advice of HR, both the claimant and his colleague were suspended pending an investigation. Also on the advice of HR, the investigator didn't obtain witness statements from the employees who were at the scene at the time. A further allegation was added that the claimant had assaulted a member of the public. And the employer told the claimant that he would face charges for assaulting a member of the public, putting himself at risk despite there being no evidence of a threat, and providing a false statement. So, rather not surprisingly, the claimant issued tribunal proceedings against the employer for victimisation. He said that he'd done a protected act, that was bringing a tribunal claim in 2013, and that he'd made a protected disclosure and had subject to detriment for that. So the disclosure was in 2012. So at the tribunal, the employer accepted that he'd done a protected act and that the disclosures were protected. And the tribunal found that the employer had subjected the claimant to 9 detriments, including undertaking a biased investigation. It said that in most cases the detriment was because of the protected act and the protected disclosures that had been made. And whilst the individuals involved may not have had knowledge of the incidents in 2012 and 2013, there was a collective memory in the organisation which was prejudicial towards the claimant. It said this had permeated through HR's approach in dealing with the situation, and there was an underlying negative attitude towards the claimant that stemmed from his disclosure in 2012 and from the Protected Act taking the tribunal procedures in 2013, and that had influenced the decision-making against him. So the employer appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal dismissed the appeal and supported the tribunal's finding. It said that there could be a collective memory within the organisation, and that can influence decisions and lead to victimisation, even if the individual decision makers have no personal knowledge. So I think for universities and other HEIs, as you have large workforces and your employees can have relatively long continuous periods of employment. So I think you just need to watch out for any sort of culture of ill will that could lead to prejudice in future proceedings. And it's important that decision making isn't influenced by that collective memory, which could particularly of protected disclosures and protected acts. And as always, it's important to handle cases with the utmost fairness and avoid biases when making decisions in relation to employees. So if we move on to the next slide, please, Natalie. And the second case involves the university and was only reported last week. This involved a Brazilian national of Jewish ethnic origin who brought a harassment claim which centred around comments in relation to her accent. She also brought a victimisation claim saying that HR had refused to share notes of a meeting because they may be used in her race discrimination claim. Now, the Employment Tribunal dismissed the claimant's claims. It said that the comments about her accent weren't motivated by her race, but because of her unintelligibility when communicating. So the tribunal said there was no harassment because the comments weren't motivated by race. They also said there was no victimisation because the meeting notes weren't disclosed, and that was because she may bring a claim, but meeting notes wouldn't have been disclosed whether that claim had been for discrimination or for something else, for example, constructive dismissal. So it said there was no victimisation. The claimant appealed to the EAT, and the EAT decided that there could have been harassment because of a protected characteristic. It said there was no mental element in harassment claim. Harassment occurs where a protective doesn't need to occur where a protected characteristic motivates a harasser. What you need to look at is the perception of the claimant and whether it's reasonable for the conduct to have the effect of violating their dignity. So the motive of the harasser isn't important, it's how it affects the complainant and whether it's reasonable to have that effect in the circumstances. It also said that an accent is an important part of an individual's national and ethnic identity. So comments about a person's accent could be a protected characteristic related to race. As far as the victimisation claim was concerned, the EAT said the tribunal had been wrong in making a comparison between this case and a similar case that didn't amount to a protected act. So not releasing the notes in relation to perhaps a constructive dismissal claim rather than a discrimination claim. The question here, it says, whether the decision not to provide the notes was influenced to a material degree by the fact that the complainant may make a discrimination claim. And it said that it could in this case, so it could amount to victimisation. So the EAT allowed the appeal and it's been remitted to the tribunal. The main point to come out of this really is that comments about a person's accent could be related to race. And as far as harassment is concerned, the motivation of the harasser isn't what you look at, it is the effect it has on the person who has allegedly been harassed. So move on to the final case that I want to deal with before handing over to Katie. And this is in relation to British Bung and Finn. And this is an EAT decision, and it confirms that comments made about physical characteristics which are predominantly associated with one gender rather than another can constitute sexual harassment. So in this case, the claimant was subject to derogatory comments referring to his baldness. And the employee brought a sex-related harassment claim, so unwanted conduct related to his sex. Now, the tribunal said that comments about baldness constituted sex-related harassment because it was linked to the claimant's gender and created an offensive, hostile and offensive environment for the employee. The employer appealed the decision. It said that baldness is not exclusively associated with men, that it can apply to women as well, can affect individuals of all genders. The EAT, though, dismissed the appeal. It said that baldness is a characteristic that's predominantly associated with men, so the remark was related to the claimant's sex. So the ruling confirms that comments about physical traits that are more common in one gender than another can potentially amount to sexual harassment, even if those characteristics don't exclusively relate to one gender. So I think the takeaway from that is that all comments and conduct in the workplace should be taken seriously. And even if something is not overtly sexual or exclusively linked to one gender, those sort of comments can still amount to sex-related harassment. Over to you, Katie.
Thanks, Jane. So I'm going to cover 3 cases, and they all have a focus on the topic of philosophical belief and religion, discrimination on those grounds. It's quite a hot topic in higher education at the moment. So the first of those cases is Ngole and Touchstone Leeds. So in this case, Touchstone Leeds is a charity providing mental health services to members of the LGBTQI+ community. The respondent made a conditional offer of employment to the claimant, who was a Christian social worker. After it had made that conditional offer to the claimant, it carried out an online search and found that the claimant had previously been dismissed from another post for posting derogatory comments on Facebook about gay and bisexual people. So on finding out that information, the organisation withdrew the job offer. The claimant challenged that decision, and the claimant was offered a second interview to discuss the concerns, but the respondent did not reinstate the job offer after that second interview. The claimant brought claims for direct discrimination, indirect discrimination, and harassment on the grounds of religion or belief. And the tribunal found that the claim of direct discrimination on the grounds of religion or belief was upheld, so that the withdrawal of the job offer was less favourable treatment on the ground of religion or belief. But it dismissed the other claims that had been brought in respect of indirect discrimination and harassment. The tribunal found that the respondent could have adopted a less intrusive approach to exploring the claimant's suitability for the post. So it should not have automatically resorted to withdrawing the job offer, but it could have allowed the claimant an opportunity to make representations before the offer was withdrawn. So the employer, potential employer, jumped the gun here and withdrew it before any discussion with the claimant. So the tribunal found that revoking the job offer straight away meant that the impact on the claimant went beyond what was necessary to achieve the charity's aims, which was to protect its service users, etc. So the case highlights, I think, the very difficult balancing exercise that employers are faced with in weighing up the right to freedom of expression and religious belief against the need to maintain a safe and inclusive environment. That's particularly prevalent in higher education when you have rights around freedom of speech and academic freedom. And the next case I'm going to move on to, Thomas and Surrey and Borders Partnership. This case really centres on what might amount to a philosophical belief. So some of you may remember the case of Forstater, which was really the case that set the bar in terms of what might amount to a philosophical belief in law. And the bar was set quite low in the Forstater decision. And the commentary that's often quoted from it is that unless a belief amounts to something akin to Nazism or totalitarianism, then it's likely that the belief will be a philosophical belief for the purposes of the Equality Act. So we all understood that the bar was quite low, but then this case, Thomas and Surrey and Borders Partnership, has provided some commentary on what the limits of that are. So in this case, the claimant alleged that his assignment with an NHS trust had been terminated because of his belief in English nationalism. He claimed that this belief was a philosophical belief under the Equality Act. The Employment Tribunal held a preliminary hearing to determine whether it was a philosophical belief or not, and found that whilst English nationalism in itself could potentially be a philosophical belief, the claimant's beliefs in this particular case didn't qualify because his anti-Islamic views, which he said were part of the belief in English nationalism, those anti-Islamic views fell outside the scope of protection. The tribunal said that the anti-Islamic views were not worthy of respect in a democratic society, as they did not respect the human dignity and infringe the rights of others. So he appealed that decision to the Employment Appeal Tribunal, and the Employment Appeal Tribunal dismissed the appeal and agreed with the tribunal. It said that the claimant's views included forcibly removing Muslims from the UK, and that in itself amounted to a generalised form of harassment. So it didn't meet that threshold for philosophical belief. So whilst the threshold for philosophical belief is quite low following the Forstater decision, what we do know from this case is that beliefs that promote hatred, intolerance or exclusion of other certain groups will not be protected. So moving on to the next one, this is the case of Orwin and East Riding of Yorkshire Council. So in this particular case, the claimant held gender critical beliefs and chose to express those in a particular way. So the council had invited employees to self-identify with their preferred gender and to share their pronouns in their email signature, which is quite common in the current workplace. The claimant decided to self-identify by adding the words XY chromosome guy / adult human male to his email footer. The council asked him to refrain from using it on a number of occasions on the basis that it could cause offence. And when he didn't do that, he was dismissed. So the Employment Tribunal found that the gender critical beliefs were a philosophical belief, but that the interference with his right to express them, so the interference with his Article 10 right to freedom of expression, was not because of his views in themselves, but because of the way in which he had sought to express them. The claimant, interestingly, in evidence, seemed to accept that the email footer was provocative and could cause offence. And the tribunal found that he had adopted that email footer not to simply express his views, but to make a point and to try and persuade the council to change its policy. So the tribunal found that he had not been dismissed or discriminated against on the ground of his belief, but rather the way in which he was expressing them in this particular way. The tribunal was critical of the council's policy in this case because it said that it had been poorly thought through and badly executed. So whilst the council had invited its employees to add their preferred pronouns to their email signatures, it hadn't given a list of acceptable pronouns, and the tribunal felt that that created too much leeway and potential for problems. So just contrasting that case with one in the HE sector, which many of you will be aware of, the Phoenix and Open University, where Professor Phoenix also held gender critical beliefs and expressed those in various different ways. She brought a claim for direct discrimination, harassment and constructive unfair dismissal. The tribunal had found that her gender critical beliefs were a protected philosophical beliefs, as they had done in this case, but they found that she had been harassed and that the university had failed to provide a safe working environment for her. So there was a difference in the way that she had expressed her views, which the tribunal found to have been done in a respectful way, versus the East Riding Yorkshire Council case. So whilst similar in some ways, the two cases highlight the complexities around philosophical beliefs and balancing the rights of individuals. Of course, it becomes more difficult in the context of higher education with freedom of speech and academic freedom, but it's important to think really carefully before taking any action against somebody on the grounds of their belief or the way in which they express them. And that brings us to questions.
Thank you, Kate. We've got some questions that all of which arise out of the Employment Rights Bill, I think. So the first one is, how will an employer be able to vary contracts when employers or their reps decline? This happens a lot, but not where the employer is on the brink. Well, I think the answer to that is that if you do want to vary contracts, do it before the Employment Rights Bill becomes law, because fire and rehire is only going to be available in those very specific circumstances to when the employer is on the brink. Any other changes to terms and conditions are going to have to be negotiated either directly with the employees if they're not, they don't have recognised representatives or with the unions or employee representatives. So it's going to be a matter of negotiation. Imposing, or sort of like the nuclear option of firing and offering to rehire, is not really going to be an option unless a university can prove that it is in dire financial straits. So I think, yeah, it's not going to be possible in the future. It is still possible now. So if there are changes you want to make, although I probably shouldn't be saying this, I would say that now is the time to probably be doing it, because later you're not going to be able to. Katie, anything else you want to add on that?
No, I mean, I think you've already made the point that the bar is going to be quite high in terms of showing the financial difficulty, etc., and the talk of potentially needing to produce accounts and those kind of things. So, yeah, do it now.
Second question. All these are from the same person. So if anybody else wants to put any questions in, then please do. What's your best guess on the future of TUPE? Don't know, but my gut instinct is that everything is to provide more protection for employees. So I don't think TUPE is going to become more lax. If anything, I think it's going to apply in more situations. I think what might happen is that some of the legislation is firmed up a bit, so it's much clearer. And perhaps there's an assumption that TUPE applies rather than doesn't apply. Don't know about the specifics. As I say, some of the things that were added by the EU through case law, I suppose, might be clarified one way or the other. But I can't imagine, as TUPE is there to protect employees, that it's going to become any more lax or more favourable to employers. Katie, have you got a thought about that?
No, I think that's the general feeling. It's definitely not going the other way. I don't think everything seems to be adding more protection. Perhaps clarification would be helpful, but we don't know.
And then the final, I'm going to put this over to you, Katie, maybe. Any idea on what the new statutory authority on enforcement of employer rights, what will it do and how will it affect ACAS? Now, I think this is the statutory authority for things like gangmasters and so on, isn't it, Katie? Is that?
Yeah, so I understand that the proposal is to amalgamate. I think there are 4 enforcement bodies at the moment. I think the plan is to amalgamate those sort of into one, but to give the Secretary of State power to enforce in respect of all of those areas. I think there will be some new potential offences created, and I don't know what the interaction is with whether it will affect ACAS. It may be that ACAS's scope becomes wider, but I don't think that it will affect ACAS in the sense of employment tribunal claims and its role that it has at the moment. But in answer to the question, I understand that there will be that pursuance of a single sort of enforcement body. And I've seen reference to enforcement agents as well. So as in people that can come onto premises and enforce. I think one of the potential new powers is to require undertakings to be made by employers. But it seems like it could be quite complex to amalgamate those 4 bodies into one, and how that might work in practice. But it is going to happen, I think, is the answer to the question.
Thank you. Well, that I think brings us up to the hour. So move on to the next slide. Just our contact details are there. So if you do want to contact us, I've just noticed that they've got our landline numbers rather than our mobile numbers, but they come through to us anyway. But if you do want to contact us, then please do. And I also noticed that Tamar has just put back up a feedback poll. So if you wouldn't mind completing that, please as well. Thank you very much for attending today. As I said, the recording will be available shortly and will be sent out to you. Thank you.